indictment I'm looking at doesn't have the name of the list. I've got an outdated copy. It doesn't put us on notice as to did they conspire to murder the child? Did they conspire to hurt the child? Did they conspire to cover up whatever might have happened? Did they conspire to commit some other unlawful act? Again, I can't go into an opening statement and explain to the jury what the facts are going to show as relates to this indictment, because I don't know what this indictment says they did.
We're going to have the jury come out and let them go. Then we can continue talking. I'm not giving them any charge of what to go. You know, we have whether this one is quashed or not. Well, it has no impact on whether the jury stays or leaves. So if you bring the jury out. What time tomorrow do they need to come in? Opinions.
So I'll be here when you tell me to, but if it's whatever is to be done, are you staying here or are you traveling?
I'm staying here.
I'm traveling, but I can make it one way or the other. 9:30? I'm traveling as well, but discretion.
Yeah, but we'll be.
No, we want them. I'm talking about the jury panel. We're about through with your motions.
I don't have another pre-trial. I do.
Well, my question is, what time should the jury come back tomorrow? In
We'll
your
be
opinion.
ready to go when they get there tomorrow.
Yeah.
I think we can get through it.
So do they have whatever elevator fixed, or do they have to come to the courtroom? So they'll know to come back. I mean, they have to come to the courtroom. So they need to be there early in the week. All right, welcome back. We still need to deal with some matters before presenting anything to you, so we're going to let you all go for the day as opposed to holding you back there. We need you to return at 9:30 tomorrow morning. And again, once again, please do not discuss the case, do not view any news media concerning the case. Do not go on Facebook or Twitter or any other social media site to try to find out something about the case. You're not supposed to be exposed to any information about the case other than that which you receive here in the courtroom. And it's very important that you follow those instructions. And so we'll see you back in the morning. I know that inquiring minds would love to know for you to come and tell them about that case you've been picked on. You're not to discuss the case with anyone. Not let anyone talk you into saying anything about this case. So we'll see you all in the morning at what time? 9:30. All right. Have a good evening. And we'll leave that. We're going to take about 5 minutes and then plow into the next matter. Which will be what?
I think we've got to finish Mr. King's conspiracy.
Tell us getting late. Okay, good.
Indictments.
Criminal conspiracy.
Your Honor, I guess just for the record, defendant Pangalangan will join in co-counsel's motion, or co-defendant's motion.
You don't know what he's accused of?
I don't know how to think.
Okay. What says the state?
Your Honor, we go back to State versus Gentry when it comes to the adequacy of the indictment. Specifically, in this case, it specifically talks about, number one, the court knowing what sentence to hand down. That's not a question. The court knows what sentence to hand down. Second, whether the defendant calls it, whether he knows to plead either an acquittal or a conviction, whether he needs to plead guilty or go to trial. And then it really talks about, and something that was interesting that I didn't note until just a few minutes ago, in determining whether an indictment meets the sufficiency standard, and again, requiring it as a notice for them of the crimes that we're charging them with, the court must look at the indictment with a practical eye and viewing all the surrounding circumstances. And they mention a case called State v. Adams, 277 South Carolina 115. So I looked at State v. Adams at the break that we just had. State v. Adams, they charged him with burglary. And in burglary, as Your Honor knows, is breaking and entering into a dwelling with the intent to commit a crime therein. The argument by the defendant was, well, you didn't say what crime I was going to commit when I broke into the house. Therefore, the indictment's insufficient. The court said no. That's not. The judge can look at all of the circumstances. And in this case, Your Honor, you've got 3 indictments. These defendants were charged with 3 indictments at the exact same time. They know what they're here for. They know that the conspiracy is simply the 2 defendants working together. If it is insufficient from an evidentiary standpoint, that would be something at the directed verdict stage. But for this, the sufficiency of the indictment, the question is, do they know what they're defending? And I think it's a little bit incredulous to say that they don't have a clue where the conspiracy comes from.
Is this a, let's say now, conspiracy, you have, what, the common law conspiracy, and what's the other?
I apologize, I'm sorry.
Conspiracy,
This is
statutory or common law. And this is statutory conspiracy.
Statutory, I think I put that, I don't have the indictment, I handed the indictment back up to you.
It says against the peace and dignity of this, into the statute. Yeah, mentions the statutes.
Again, a burglary case where he says, we broke into the house at 1517 Maple Street with an intent to commit a crime therein. Yeah, that puts you on notice. You know what it is you can defend. We broke into the house. We didn't break into the house. We were invited to the house. I have an alibi. I wasn't at the house. But for this to say, they conspired to commit some unlawful purpose, unspecified, and bring 2 separate charges. And so they could be a conspiracy to commit murder. It could be a conspiracy to hurt this child. Or it could be a conspiracy to cover up whatever happened afterwards. And if we go into an opening statement, again, those are wildly distinct, or at least very distinct, factual scenarios.
Well, you want them to say that they conspired to commit a murder or conspired to cause great the statute involving assault, great bodily injury on a child.
Or they conspired to commit misprision of a felony, or they conspired to cover something. I don't want them to do that. What I want you to do is to quash the indictment.
Oh, I know. But if they're required to do what you're seemingly suggesting, that elevate the crime to maybe accessory before the fact or accessory after the fact. Are you asked? Is that what you're sort of seeking?
No, and they haven't.
Well, if they did, if they did what you're saying they should have done, does that make them, would that make them an accessory?
I don't think they could, not if they're, I don't think they can be an accessory to a crime they're accused of having committed. I think they could either be a principal or an accessory. So if they're accused of having committed the murder, I don't think that they can be an accessory to that murder also. I think that what they should do, if they're going to say you conspired to
You
commit.
said you can't be charged with the murder and accessory before the fact.
I don't know, sir. I don't believe that you can. I think you are either a principal or an accessory. And I also think the accessory before the fact or the principal to distinguish is sort of academic.
Well, or
in this-
maybe this discussion is academic, because where does the law require that you specify anything more than this indictment does?
I think if this is,
It doesn't say, I mean, do you have any authority that the state must specify that they're in conspiracy to cause great bodily harm, conspiracy to commit a murder, such as your burglary or the burglary that was referenced, conspiracy to commit a burglary? Do you have authority where the indictment must be more specific than this?
Your Honor, I do not have authority at my hand which says that. My understanding is the principle is that this
All right.
indictment is to
Well,
serve.
if it exists, Mr. Phillips would have it, I'll tell you that.
My understanding, well, I don't know. He didn't make this motion, so maybe he didn't look at it.
He
as
joined in, though.
and he may be finding it. However, if it's a notice document, again, I don't need to repeat my argument. I don't know what I don't know how to, I don't know what to defend.
Okay.
Thank you, John.
Yes, sir. Mr. Phillips, anything further?
Not on, well argued.
Anything further on this issue?
No, sir.
I think the indictment is sufficient based on the statute. And if the state fails to connect the dots and prove a criminal conspiracy in violation of the law, then the court will direct a verdict.
The only thing I will just say that we have the presentation of reckless disregard for human life, but conspiracy is the intentional act. I think we do have that contradiction. I want to keep bringing it up.
We'll just reflect on the death penalty case they had in Clarendon County, where boys were accused of going in and robbing a convenience store and killing the owner, facing the death penalty, and the only thing that they came out being convicted of was criminal conspiracy. So it's standalone. And the solicitor there was happy at least he charged with criminal conspiracy.
We're not really concerned with saving the case.
All right.
This is-
What's next?
Yes, Your Honor. The defendant, Pangalangan, does have a motion for suppression of untimely and prejudicial disclosure of evidence. A couple of different things. There's multiple pieces of evidence that I would argue is disclosed late, but I'm going to focus on one first, specifically on August 18th, the state conducted tests on a vehicle in which the decedent was found. That was 1,474 days after the defendant's arrest on August 5th, 2019. Failed to disclose those video recordings or tell us about it, I believe, in the status conference that we had until Wednesday, August 23rd, 5 days later, with no accompanying information, just 2 short videos of the vehicle and some tests being done, and then subsequently disclosed Volkswagen certifications for Jason Vigalotti and Michael Malinsky on this Friday, August 25th, with no additional explanation or documentation, no reports. It appears, based on what is presented in the witness list, that the state is going to either present testimony or presentation of these videos from Michael Malinsky and Jason Pangalangan in this case. Now, again, I don't want to muddy the water, so I'm going to stay with just this one first. In looking at kind of the timeline here, we go all the way back to where I first came in the case. On November 9th of 2022, I mailed a copy of the motion for discovery, Rule 5, Brady and Rule 5, to the solicitor's office. On November 16th of 2022, Solicitor Duffy Stone sent a letter to all the defense counsels indicating his intent of calling this case for trial in August. And then on May 24th of 2023, our Supreme Court issued a General Sessions docket management order. It became effective on July 3rd of 2023, requiring the timely disclosure of discovery, specifically indicating that the case should not be put on a trial docket until all the discovery is complete and been provided to defense counsel. Specifically, it says the solicitor shall not list any case in which the state, the solicitor, and law enforcement has not complied with Rule 5 and Brady at the time of the proposed trial docket is transmitted to the chief and the clerk of court and used in order of terms of discovery. It's any material subject to discovery under Rule 5. And then specifically on June 21st of 2023, we received an email from the clerk's office scheduling this case for trial during this court term of August 28th. And then on August 7th, I emailed a supplemental motion of discovery to them, requesting different things, specifically would have been additional video recordings. Then on August 18th, we had our status conference, and these tests were conducted on the vehicle. And then on August 23rd, again, that's when the disclosure of the videos were provided in an email. At that point, again, no accompanying information. It was just 2 videos. And then 2 days later, last Friday, we had certifications for Jason Pangalangan and Michael Malinsky, just Volkswagen certifications, no reports of what they did. I did a follow-up email on August 26th, the next day, to Solicitor Thornton asking or inquiring when the videos were done, who was present when the videos were recorded, if background checks on these potential witnesses were done, the subject matter on which these potential expert witnesses are expected to testify, and the substance of their testimony. In response, Solicitor Thornton provided the following. Quote, the videos were done last Friday. Present were Malinsky, Pangalangan, Dylan Hightower, and Jason Chapman. They are the same folks who may be heard and seen in the videos. Do not have wraps on them, but we'll get those to you Monday along with the others. Sorry, Madam Court Reporter. Those are the same folks who may be heard or seen in the videos. Do not have wraps on them, but we'll get those to you Monday along with the others. They may testify as to the vehicle, its operation, and its interaction with the key fob. Also, whether the key fob can be locked in the car. And so specifically, again, I'm not going to muddy the waters with the others. Take this one piece at a time. When we're looking at how this unfolded, it's been 1,474 days since the defendant's arrest, 280 days since Solicitor Stone's letter calling the case, saying he's going to call the case for trial in August, 91 days since our Supreme Court issued the General Sessions docket management order, 63 days after we sent an email or received an email from the clerk of court's office scheduling this case for trial, 16 days since we sent a supplemental motion of discovery, 5 days after the tests were conducted, and then 5 days before trial for just the videos. I got to be specific here. My motion is to suppress the testimony and videos on this specific, and again, I'm going to the others in a second, but specifically suppress this evidence, not only based on Rule 5, but also given the General Sessions docket management order in Early v. State, our South Carolina Supreme Court, that's 418 SC 255, noted that the purpose of Rule 5 is for the defendant to have a meaningful opportunity to prepare a defense based on evidence that may be introduced at trial. Given this situation, the prejudice is now that I don't have the time to retain my own expert, to review the car, inspect the car, review the videos,
or potentially have rebuttal expert testimony in trial because of the 11th hour disclosure of this evidence. So to me, our specific arguments that the prejudice is on its face, it's apparent through the late nature. It's 4 years later, and we're having potential expert witnesses, and the way it's done on Wednesday and then Friday after it was done the previous week leaves us in a position where I don't have the ability to retain my own independent expert, conduct tests and inspections, potentially have rebuttal testimony. So I'll save the rest, but I think specifically, given under what's here, and I hate to pound the chest a bit, but I think there has to be sending a message that the whole purpose of timely disclosure of evidence means something. And having this is a tactic that puts defense counsel at a disadvantage and impairs the defendant's right to a fair trial, our right to present a meaningful opportunity having meaningful opportunity to present a full and complete defense. And that certainly violates the 5th, 6th, 14th Amendments to the United States Constitution, Article 1, Sections 3 and 14 of the South Carolina Constitution. It's just fundamentally unfair to have discovery provided in this manner, specifically when there's no reports given and given the just over-dilatory amount of time provided. I'll take it piece by piece, but that's the first set.
Piece by piece on the same issue?
Well, so we have multiple different issues related to discovery, but for the JED, I figured it's easier for the record, easier for Your Honor, if we take it by evidence.
All right.
Thank you.
Anything you have to say on that, Mr. Boyd?
Your Honor, I would like to join in the motion in all candor. Mr. Jackson and I are later to the things than Mr. Phillips, and I don't know that.
All right. Response by the state.
Thank you, Your Honor. May it please the court.
Yes, sir.
You know, I think this may fall under the category of no good deed goes unpunished when I provided something I'm not required to provide. Obviously, under Rule 5, I don't have to tell Mr. Phillips who my witnesses are or what the substance of their testimony is going to be, but I did try to do that when he asked. I would also note for the court, and it's actually in Mr. Phillips' motion, on page 6 of 11, there's this thing we call continuing duty to disclose. So these videos were created at a test determining the locking and the interaction of the vehicle with the key fobs on Friday, and it was Friday, I think it's the 18th, and it may have been the same day as our status conference, but it was late in the afternoon. Mr. Hightower was present with them. The videos in question, I think the two videos together are a total of a minute or less than a minute. And they were done, it was created on Friday, that Friday the 18th. I believe they were uploaded into our system by Monday, and I sent them to him sent the two things on Wednesday. He emailed me back and asked, the email he basically read you, Judge, who are these people and what's the substance of their testimony, which I gave him the basic tenet of. But, in the case management order, I've heard he's the second or third defense lawyer that I've heard get up and say that it says discovery's got to be complete. What it says is that we have to be in compliance with Brady and Rule 5, and stuff like this is why. This information didn't exist until that day. And I turned it over, it was done on Friday, I turned it over the following Wednesday.
Is this docket management order now being elevated to the status of a statutory rule?
Yes, sir. I'm getting beaten up with it just about every time. The first thing they say is, well, Judge, they gave me something, they gave me a piece of paper after the case was put on the trial docket, and that's in violation of the docket management order, and it isn't. What it says is we have to be in compliance with Rule 5 and Brady. And I would also point out that... It also
says judges are to manage the discovery, and judges are to do this, and judges are to do that.
Yes, sir. And I would also...
how it's... is that really a misnomer?
I'm sorry.
Is that a misnomer? Docket management order? Is that the...
I think it's an attempt to help everybody manage the docket properly, Judge. Beyond that, those decisions are made above my pay grade. But I can tell you what it says, and what it says is that we're supposed to be in compliance with Rule 5 and Brady. The other thing I would point out is...
It also says judges are to do these first appearances and second appearances and coordinate this and schedule that, and now it's being cited in motions. A motion to suppress based on violation of a docket management order.
I have to jump in, Your Honor.
No, you don't. No, you don't. You don't have the privilege of jumping in. That rules are adopted in various ways, generally through the legislature, or if the Supreme Court's going to amend the rule, then there's a period of objection now, or a period through which it becomes law unless whatever procedure takes place. But this is new to me, that an order trying to manage the docket is being elevated in a murder trial as a basis for a motion to suppress. Now you can jump in now.
Thank you, Your Honor. That is, the General Sessions docket management order is at the bottom of the pile of the things that I'm relying on. We have...
Well, I realize that, but you're including it in your argument.
Sure.
So, I mean, you've got enough to go on without throwing that in there.
Well, I think ultimately the Chief Justice would agree for the Supreme Court to issue this. It must have some basis in that, but also due process, fundamental fairness, obviously our right to confrontation of witnesses, her right to have effective assistance of counsel.
I think it muddies the water when you cite it as a basis for one of the bases of a motion to suppress, and that's my position on it regarding this docket management order. It's obviously important, but it includes a lot of things that are not mandated by the discovery rules.
Yes, Your Honor. And I guess just to be clear, my request is also made on the defendant's right to a fair trial, his right to confront witnesses, confrontation of witnesses, compulsory process, meaningful opportunity to present a full and complete defense, effective assistance.
Well, we heard you the first time on all those other ones.
And Rule 5.
Okay, I understand. I understand your position all around, but
It's just, it puts, from a defense attorney standpoint, I'm now in a position I don't have time to do what I need to do.
I understand. You said that the first time.
Nothing
Go right
further,
ahead.
Judge.
Well,
Your Honor, I apologize. May I add one thing?
yes, sir.
I was in the process of saying this, and I stopped, and I apologize for interrupting the court. I would also point out, this is about functionality with the fobs and how the fobs interact with the vehicle. The vehicle's been impounded, and defense counsel could have gone and seen it or gone and looked at it anytime he got ready. We haven't prevented him from doing so, just like we did.
Yeah, well, the point is a valid point. Offering an expert witness and an expert witness's report 3 days before trial or 5 days, well, there's no report. So what are they going to? What's the basis? What are they going to testify to?
Your Honor, they will testify as to the fact that, as to how the remotes, the key fobs, operate when the vehicle is running versus when it is not running. It's a demonstrative. You can look at the videos and see what they're doing. It's not really expert testimony in the sense like a DNA analyst or something. They're basically, and that's why it was video.
That's going to be my question. What's expert about that?
It isn't. It doesn't require unexpert opinion. There isn't going to be opinion testimony. It's just it would be factual statement.
In response, they provided 2 days later, Friday, certifications from Volkswagen. Whether they end up pushing it qualified, they're going to have these individuals up there in capacity as somebody that has at least some type of training and experience that the jury does not have, whether they try to qualify or not.
I'm going to defer ruling on that, but I tend to agree with the defense to the extent of offering an expert a week or 3 or 4 days before trial. But I'll defer ruling because I haven't heard enough testimony or anything about the case to get a sense of it all. I'm sure the case is not going to turn on what they did last week.
Well,
I would hope not.
our specific thing would be that the state is going to rely heavily on that. And with
How do you know that?
Well, again, I would be able to hire my own potential expert to do their own inspection, conduct an independent, potentially have a rebuttal if something.
Well, I mean, you've got time to do that if you want to do it. I said I'm going to defer ruling on the motion.
But I'm in trial now.
Well, if you want to get someone from Volkswagen to go out there, if you want to, I don't know. I'm deferring ruling on it, but you're continuing to argue it, basically.
I understand.
All
I'm
right.
just making my point clear.
What's the next issue?
Yes, so the additional issue, there is a CV that was provided very recently, I think within the last, solicitor, correct me if I'm wrong, from the last week or so, David Egerton, and there's no reference in discovery of who this individual is. And so I asked today, the basis of the testimony, and I think this will parlay into another motion that I have, that this individual is going to testify as an expert witness as to related alleged drug use from the defendants. And so I think we got a couple of different issues related to that. One, again, I understand his position is that he doesn't have to give us any heads up as far as his witnesses, but now that we have that, we certainly can wait to have that resolved because I do have a motion related to that, not only the 404B, but also additional motions related to that. So,
I don't make preliminary rulings on these evidentiary issues prior to the trial.
so the basis we'll just address it when they call the witness.
Okay.
Based on the solicitor's statement earlier, as far as their intent is only to present the one statement from the scene, the other argument that I would have related to discovery is no longer necessary. I understand your ruling is certainly in abeyance at this point, and so we'll move to the next motion.
Okay. I only have one thing in abeyance, right, or two?
Specifically, I believe whether you're going to keep out testimony and evidence. Essentially, my motion to suppress the videos.
Oh, the key fob type testimony.
That's correct.
Okay.
Now, one matter may be cleared up from the solicitor. Again, the lead investigator on this case, Sergeant Macurella, I hope I pronounced that correct, unfortunately passed away, it looks like, on January 16th of 2021, and he handled a great deal of evidence. And I think, Your Honor, what you just said, that you're not going to do any pre-trial evidentiary rulings. We'll have to just address it as things arrive during the trial. But we have significant issues of potential hearsay, not only investigative hearsay pursuant to State v. King, but also just the hearsay level of the documents that he dealt with, because we have a confrontation clause problem as well, and then foundational issues and potentially authentication issues. So a lot of, unfortunately, happens when you have one individual who worked on evidence that has essentially a motion for suppression of evidence due to unavailable witness. However, based on Your Honor's statement that you're not going to provide any pretrial rulings on evidentiary, I don't want to go too far in, Your Honor, to say that you're not ready to address that.
Well, I'd still love to know what's coming down the pipe. You said
And And unfortunately, the problem,
suppression based on a
the unavailability.
unavailability of a witness.
Yes, Your Honor, and the problem that I'll have at this point is I don't obviously have privy to what evidence the state is going to seek to admit, and so that is a conceptual problem of mine that we'll just have to address at the appropriate time. But I wanted to make sure Your Honor is aware of that issue.
Okay. Any comment the state wants to make about that?
I don't understand it, Your Honor, I apologize, but I suppress what? I can't respond, he moves to suppress what exactly?
Well, I guess the first, if the state's willing to identify what pieces of evidence that only Sergeant Macarella handled that they intend to seek to present, then we can certainly address it piece by piece, or we can wait for the trial.
See, that's having a trial before the trial.
Well, I'm just trying to, the judicial economy, Your Honor, if we handle it now, then we don't have to stop.
Yeah, well, a lot of things that are labeled as judicial economy are really judicial delays, but it's all a matter of perspective. What's the next one?
Yes, Your Honor, the next is kind of a joint motion for the state to disclose 404B Lyle evidence, and of course, defendant's objection to the introduction of inadmissible propensity evidence. And so, with that motion to disclose what potential 404B evidence, that kind of then is bolstered by our objection to it.
What type of propensity evidence are we dealing with here?
It depends what that's why I have the motion to disclose the 404B, because I can't unring the bell if it comes out in trial and I'll have to move for a mistrial.
Well, that's when you make an objection before the bell is rung.
Unfortunately, sometimes that's impossible. And so I'm trying to deal with that now so we don't have a mistrial issue.
Okay. Response by the state.
Yeah, we're not going to offer any propensity evidence. I don't think that's a problem. I think any evidence that we would offer, again, the defense should have time to object. But I'll tell you that the only thing that falls under res gestae as well as Rule 404B that would even be arguable are two witnesses. One is Brittany Honeycutt and the other is Lindsay Lewis. Both of them have given written statements. I would glad to give you a copy of those as well as the defense. The defense already has a copy of the statements. And those statements, one of the witnesses was actually with Rita Pangalangan for the Friday, Saturday, and Sunday. Excuse me, I take that back. I apologize. This happened on Monday. The child was killed on Monday. Rita Pangalangan left her child with this babysitter Friday, Saturday, and Sunday. And she describes basically Rita Pangalangan leaving the child with her and taking off, and she doesn't see her for the full weekend, didn't know she was leaving. That leads literally into that Monday. So this is literally part of the case itself under res gestae. The other witness is somebody who lived with Rita Pangalangan through the going up until, I believe, August the 1st. This happened again on August the 5th. In her statement, she said that, among other things, and again, I'll give you the full statement so you can view it, but among other things, she said that Rita Pangalangan told her, I need you to take the child, and I need you to take her with you. And she said, I can't do that. If the witness says I can't do that, I'm going to work. And she said, just take the child with you to work and put her in the car. That's what I always do. That, to me, Your Honor, again, this is on August. This is the time frame that she's actually leaving with Rita Pangalangan. It goes directly to the reckless disregard for the safety of the child being something that Rita apparently does pretty consistently, that she used to put the child in the back of the car. Again, those statements are all written. The defense has full statements of these things. They are about 2 pages apiece. In fact, Ms. Lewis's statement is two pages and a quarter. Ms. Honeycutt's statement is 4 pages total. And the defense has that.
Yes, sir.
Thank you, Your Honor. evidence of that nature that's not resulting from a conviction must be explained or at least proved by clear and convincing evidence to be admissible. And pursuant to State v. Gore, when a prior bad act are similar to the one where a person's being tried, the danger of unfair prejudice is enhanced. So not only under the 404B, if an exception applies, we argue that it doesn't, but if an exception applies, you still have the 403 analysis, that the probative value of the evidence is substantially outweighed by its prejudicial effect. And here it's not as a result of a conviction, and it's similar, so the danger of unfair prejudice is enhanced under the case law. We would argue that this is the exact, again, under propensity evidence, is where there's smoke, there's fire. This is the exact reason why this should not be presented.
All right.
Yes,
You want me to review the, you can give me a copy of them
sir.
to
I'll
look
give
at?
you the statements as well.
Yeah,
I'll also
okay.
hand you State v. Martucci, which kind of outlines the use of both 404B and res gesta. It's actually a very good overview of the entire analysis, and in particular in child abuse cases. So I'll hand you that, and I'll give a copy of that to the defense as well, and I will give you these statements.
Yeah, it's just my offhand reaction to what I'm hearing without, looking at cases and all that, is that the context of it all, if the state is to prove a case involving the death of a child, and you have, I guess the defense is that it was an accident, it was inadvertent, it was a loving mother who would never do anything to hurt her child or whatever. I don't know that of course the state can't wait until the defense decides to offer that defense, because the defense may not offer anything. So the state has to be able to prove its theory, and I would think through circumstantial evidence, based on whatever circumstances exist surrounding the situation. I want to read these cases and
Yes, Your Honor.
deal with them, hopefully in the context of all of this. Every case is unique.
That's it. It's that one case. It's quite frankly such a good analysis, Your Honor, that it mentions other cases, but it summarizes it all very well. And can I make copies of these? I have hole punches in them.
Sure.
I don't want to hand out the court something.
These are some, these young ladies up here, they're very efficient with all of that.
Sorry. Thank you.
Well, and again, remember the course of 404B law has changed away. Specifically, we need to look at State versus Perry, 430 SC 24. But again, going back specifically here, in what I have for Your Honor, so you can follow when you have your ability to read their case, what was handed to Your Honor is the objection to 404B, again, what was marked as defense exhibit number 10. Under State versus Fletcher, our Supreme Court explained that clear and convincing evidence is the degree of proof which will produce in the mind the trier of facts affirm as the allegations are sought established. That's when a prior bad act does not result from a conviction. It must be proved by clear and convincing evidence. If you have someone come in and say, well, I was told this a few days before, and it's not a result of clear and convincing evidence, and you take based off of the case law that it must be proven by that level of threshold of an evidentiary standard, and then you put that in context of State versus Gore, that when a prior bad act is similar to one for which the defendant's being tried, the danger of unfair prejudice is enhanced.
We know that.
And so our position would be even if it satisfies the 404B exception in Your Honor's minds, then it would still have to survive the 403, and our argument would be that it survives neither, but certainly not the 403, given the context of what's provided, that its prejudicial effect is highly outweighed, substantially outweighed by any probative value that be presented.
That leaving a child with a babysitter would tend to think that the person is guilty of murder?
That's exactly the argument he said they're going to make.
Okay.
I mean, that's exactly the argument from which they're
Well,
going to say.
I mean, your case analysis, you're saying about prior bad acts, asking someone to be a babysitter, is that a bad act? Or to tend to my child, or have her wait in the car while you go to work, or whatever the facts are?
That's just not the way the state's going to present it.
No.
I wish it was that.
Well, all right. Well, we'll evaluate all this, but for me to judge rule on this before the trial, that's another reason I don't rule in advance on
Understood,
critical issues.
Understood, Your Honor. The next motion really deals with, I think Solicitor Stone said he's going to mark or pre-mark the photographs. We would have 4 or 3 objections to photographs there.
Well, anything that they're offering you do not object to.
I haven't seen what they're...
You don't know of anything that you do not object to.
That's the problem. Yeah.
Okay.
I'm sure I will.
Well, what about the photographs? What's the story there?
I don't know if they had an opportunity to pre-mark anything yet. I know they were in the process of one.
You have gory photographs.
We are not, Judge, here's the only, we've actually, going through, I think the Supreme Court just actually handed down a decision, Nelson, State versus Nelson, last week, or week before last. It has not become permanent yet, but it talks about autopsy pictures. We actually went back, we were going to offer one autopsy pictures of the child's leg. We've taken that out now. We do offer scene photographs. We have the child that was actually taken out of the car at the scene and on the scene, and that's the only photographs we have. I'll be glad to hand those up to you. But scene photographs, even if you look at, say, versus Collins, which is a case in which you have an actual animal mauling case in which the child autopsy pictures were taken and were admitted into evidence.
Judge Birch's case out of Chesterfield.
Yes, sir. And that, and even in all of those cases, they're all referencing pretty much autopsy pictures. The only photographs we're offering are scene photos. This is literally how the child would have looked in the car, the way the child was taken out of the car, and then the way the child was left after she was taken out of the car. Let me... photographs. And I'm going to, at this point, Your Honor, if I could go ahead and mark those state's exhibits so that we will have reference to them.
Yes.
You'd like me to do that? I've got a sticker right now. Yes, sir.
Your Honor, could we look at those briefly before they're handed
Sure.
out?
I'll be glad to show these first to the defense. I'll also hand Your Honor the State versus County, which is what we will rely heavily on. This is a South Carolina Supreme Court case that outlines crime scene photos. In that situation, this is the pipe bomb case of the 15-year-old girl that was, I believe, raped and murdered, and then the 2 defendants put a pipe bomb in her mouth and exploded it. The crime scene photos were taken not immediately afterwards, as they are in this case, but 46 days later. In fact, the defense brought a big objection to the fact that these are not actual crime scene photos. This is how the body was found by law enforcement. South Carolina Supreme Court said this was proper to allow those into evidence under the same analysis that we do of the other ones, because it shows how the defendant left, what the defendant did, how they left the victim, and that was the very first look that law enforcement have. In this case, the photographs that we're offering, and I'll hand these up to you. I think I've shown them now to the defense. This is of the very day, within moments after the child was taken out of the car. This is State's Exhibit 1, 2, 3, and 4. I'll hand those up to you.
Can you make a photocopy of these for me? That's okay, it's fine. Are those the photographs you were referring to, Mr. Phillips?
Yes, sir. Now that we have identified photographs, specifically as stated by Solicitor Stone, under State v. Nelson, that did come out back on August 9th from our South Carolina Supreme Court. Specifically, our position is that we move for suppression of the evidence here based that the photos have little to no probative value as to any disputed fact or to an element of murder. And again, under our 403 objection, another case that was recently decided by our Supreme Court, State v. Jones, that was filed on March 29th, the courts quoted, "It is well settled or well established that photographs that are calculated to arouse the sympathies and prejudice of the jury are excluded if they are irrelevant and unnecessary with the issues at trial." And of course, the buzzword is inflame the passions and prejudice of the jury, specifically that the jury would make a decision based on an improper basis, not based on the evidence. Seeing the photos alone would invoke such a response that the jury would not base their decision, their verdict, solely on the evidence, but based on the graphic nature of the photographs. That any probative value of those photographs are substantially
Do you
outweighed.
object to all the photographs?
Yes, Your Honor.
All right.
With Mr. King, we joined that case.
Yes. All right. So we'll address that issue as the evidence develops.
Thank you, Your Honor. And our specific issue is just that a pathologist will be able to testify, explain the injuries, that the state will have other means of evidence that they can present through testimony of the pathologist, through the people that were present at the scene, to explain what was there. That's not necessary to actually have to show the photographs as far as what actual probative value would be presented by actually having to publish those to the jury.
All right, we'll address that issue in the course of the trial. Certainly they can be marked for identifications prior to being admitted or not admitted. What else do we have?
Thank you, Your Honor. The defendant, Pangalangan, moves to prohibit any inadmissible hearsay testimony regarding references to any illegal activity that's not contained within the scope of the indictments, and that's under the 5th, 6th, and 14th Amendments to the United States Constitution, Article 1, Section 14 of the South Carolina Constitution. We look at Rules 801 and 802, the South Carolina Rules of Evidence. Specifically, this hearsay evidence that implicates the defendant or infers the defendant's involvement in some type of illegal activity or illegal doing of, I believe, based on my discussion with Solicitor Thornton, they plan to call an expert to testify about drug use from either one or both of the defendants. And specifically, given that our argument would be that they not be able to present that, I understand that they now have what was presented to us recently, a CV of a toxicologist, but wanted to raise that motion.
All right, this,
I'm not sure how that's hearsay, Your Honor. Both defendants had methamphetamine in their system from blood draws. One had 400 nanograms per milliliter. The other one had 480 milligrams per day. I don't see how that's hearsay. It was actually blood taken from their body. It was taken to SLED. It was tested by a toxicologist at SLED. The child also had her blood taken as well and tested. That was a toxicologist by the name of Demi Garvin, who's also on our witness list, and her CV has been provided, although Rule 5 doesn't require that. So from the standpoint of, I don't plan on offering any hearsay that's objectionable throughout any part of this trial, but certainly blood draws aren't hearsay. I'm not sure how that's...
And the blood was drawn when in proximity to the...
Right after the event. They were actually, both of them were taken from the crime scene to the hospital, and were taken and had their blood drawn at the local hospital.
And Your Honor, I guess let me clarify. I had some confusion there. Don't have any issue as far as toxicologists. They're correct. That's not. You're saying whether we had any law enforcement officers make references to drug use or the fact of the toxicology results, if any of the law enforcement officers were to discuss that. The other portion of that would also be an argument under Rule 403 that the probative value of providing that they had allegedly this substance in their system would be substantially outweighed by its prejudicial effect. And I understand that all evidence generally presented by the state is prejudicial, and our position is in this case how it relates to what they say recklessness. I understand that their argument would be that goes to their theme or theory, but our position is that if the probative value presented there is substantially outweighed by its prejudicial effect, because there's no additional evidence that corroborates or supports that somehow that resulted in what occurred that day.
And I would join in that argument as well as object to the introduction of testimony or evidence as to any uncharged crime. And they're not charged. Search warrants were executed at the home, at both homes, as I understand, on the vehicle, etc. There were no drugs recovered. They're not charged with possession of any drugs. And I think again, as was stated by counsel, that the probative value is far outweighed by the prejudicial effect. And so I'd ask for a ruling on that at least before we attempt to unring that bell that you said we can't unring.
If someone is in the, I guess on a drug binge, and is accused of committing a crime, is there authority out there that addresses that question?
And not to jump in, but I would just say there's no evidence that they're on a drug binge. If somebody tested positive, they could have done it 3 days before. That stays in your system
That's
for several
hypothetically.
days.
If someone is on a drug binge, I'm sure, as is the case in many, many murders, many, many crimes, is there authority that addresses that issue?
I'll certainly research it. Our position, again, to the
That would be
relevant...
the question. If the state is saying, well, they were more focused on using drugs and tending to the child, and so therefore the jury should know about that, then there should seemingly be some case authority one way or the other on the issue.
I think there would have to be some threshold evidence showing that they're on a drug binge, because somebody could test positive.
Well, I just use drug binge as an example. The same thing can apply if heavily under the influence. If they were tested around the same time and had all these drugs, and a toxicologist will testify as to the level of drugs in their system, all that. I'm just, as you all are musing over these legal issues that I'm going to be asked to rule on, I'm posing the question, is there authority that addresses that issue in general?
Your Honor, I don't have a case to cite, but as far as a probative value, my client is accused of having done is to be present when a child that he has no authority over. If he had tried to take this child, he'd have been arrested for kidnapping. It's not his child. He's not a guardian. He doesn't pay support. At most, he's present at the scene. And
well, so mere presence does not make a person guilty. We know that.
Right.
But that's a separate issue.
Well, I understand that, Your Honor, but without some threshold, well, I can address it when it comes up.
I don't even know the facts. I mean, we're just having a conversation more than anything, and I'm raising questions as to, You all throw out the issues, and I'm just asking questions.
Your Honor's close to knowing the facts because this is going to be one case where I don't think the facts are going to be a huge issue. What occurred pretty much occurred, and it's on tape. And we could almost go to closing argument.
Yeah.
So just to be
I'm just, since you don't have an answer to the question about whether or not there are any cases that address the issues of evidence of intoxication by the defendant, is there anything out there that addresses that? You say you don't know anything about it. I'm now asking the solicitor.
Yes, Your Honor, I just wanted, so I can, as I'm looking, if you could clarify, I just want to make sure exactly, you're saying a case that would say, that would allow the state to present toxicology in a case that doesn't deal with drugs?
Cases that deal with the issues in general. No case, each case is going to be unique in its own respect, but you have principles that govern the types of situations. Mr. Stone.
First of all, Your Honor, I know of no case that specifically says that if you're high on meth or if you're drunk or if you are high on crack cocaine or whatever, that you can't introduce that if they're committing a crime. I can't come up with a single case that says no. I think that there is so much prevalence of drug use and crime in our jurisprudence that we literally have cases that say, and I'm quoting here, voluntary intoxication or the use of drugs does not constitute a defense to a crime. So it's the exact opposite of what they're arguing. It's such a prevalent issue in what we deal with in the courtroom that the Supreme Court, in State versus Hartfield, 300 South Carolina 469, literally goes to the trouble to say, by the way, that's not a defense. That you voluntarily use drugs and therefore you can use that as a defense. I think that's an indication how prevalent this is throughout our entire jurisprudence. I know of no case that says that that's not relevant testimony for a jury to know that you are under the influence of, whether it be meth, whether it be cocaine, whatever, from an illicit drug standpoint.
Well, the defense seems to be saying, maybe yes, maybe no, that acknowledging that the defendants were on meth to a significant degree, the jury should not know about it. And that's the quintessential question in the case. And the state says, well, the jury needs to know about it.
I think it goes, you talk about a case in particular with the murder charge of implied malice. And what we're talking about is somebody that has a total disregard for the safety of the lives of others. And you're talking about that from the standpoint of somebody who puts a child in a car and leaves that child in the car for 5 hours and 41 minutes on August the 5th in rural South Carolina in direct sunlight. The child literally cooks to death inside the car. And I think it's inevitable that the jury would say, what were you thinking? Because I promise you, Your Honor, as we're playing that video, that question will come through just about everybody's mind that's watching that video. I know it's come through mine 100 times. What are you doing? What do you think? Why don't you get the child out? At one point, they actually find that they've locked the keys in the car. And instead of breaking the window, they leave and go get a spare key for an hour. So I think if you look at that situation, the fact that they are high on meth becomes extremely relevant because it answers, what are they thinking? They're not thinking. They're more focused on, they are high on meth, therefore they're putting that child's life at risk because of that. Then the question becomes, does that voluntary intoxication give them the defense? Which is why, by the way, I have that case, just to make sure that we weren't going to go down that road. It is a crucial part to this case. It is central. And I can't fathom that there is a case out there that says that that would not be relevant.
No cases that would say it's not relevant. Any case that says it is relevant. And since you brought your whole team here, you can have 15 researchers on that question. Well, any other comment on that issue?
There's no connection between the two. If they put the child in the car and drove to get methamphetamine, if they robbed a methamphetamine dealer, if the child was positive for methamphetamine, but if someone has used methamphetamine, as counsel has argued, within the last 24 hours or 48 hours, the act of leaving the child in the car is no more culpable, it's no more reprehensible, and it's no less. I can assure you nobody's using voluntary intoxication as a defense. I can allay the solicitor's concerns on that. Am I correct?
You're correct.
We haven't discussed that, but I'm pretty sure that's not going to be a defense at all. There's just no nexus between the two. I
Do
mean,
you agree that homicide by child abuse cases are different than regular cases, or no?
yes. In a jury's eyes, I think that they are. I think
I
anything.
mean, evidentiary speaking, if you're trying to prove neglect.
Well, this is not a homicide by child abuse case.
Well,
This is a different statute.
it may be a different statute, but it's still, I mean, sort of the same theme, isn't it?
No, Your Honor, because the elements of proof that are within the homicide by child abuse statute are different than what's presented in the murder statute.
Okay.
So, unfortunately, that's...
Well, the case that you handed up, is that a homicide by child abuse?
It is, and it describes all of those issues, including the concern that you just had, the comment you just had about the difficult nature of charging. And I think they actually included a footnote, not a footnote, but actually a paragraph from former Chief Justice Toll that talks about that from, in fact, the Fletcher case, which the defense actually referenced earlier. So all of that is in the Martucci case, which is the case that I handed up.
And so, our position with that is even if there is relevance, even if Your Honor finds there's probative value, it still, as Your Honor knows, has to be weighed against its prejudicial effect. And we argue it's substantially outweighed by its prejudicial effect, given the fact that there's no further evidence as far as, again, exactly how that had affected. That's our position, given that it's not a homicide by child.
Yeah, I would expect that to be your position.
coupled with the fact that they don't really, it's on video, as Your Honor must be aware by now. The child is on video being carried, placed in the car, closed the doors, walked away. It's not disputed. It's not somehow worse if someone is positive for methamphetamine and does that.
Maybe they were sleeping inside for 6 hours or 8 hours or whatever.
Well, not if they're doing methamphetamine.
Well, I mean, I don't know. What kind of information is the jury entitled to know about this unexplained death?
It's explained. I mean, we can stipulate to the cause of death, which is one more reason we don't need the photographs that were there earlier. I mean, the cause of death is, and again, I speak for counsel without conferring, but I think it's beyond dispute.
All right.
That as a solicitor stated, this child basically.
Okay. All right. What other issues do we have?
Based on the Solicitor Stone's statement as far as the statements that they plan to seek to admit, we get clarification, Solicitor Stone. So for Defendant Pangalangan, there's only one statement that the state seeks to admit at trial. Is that fair to say?
The judge, as I told you earlier, there are two statements. One is by her at the scene, which says, I went inside, I put the child in the car, I went inside to get cigarettes, I came back out, and we had the keys were locked in the car. The statement from Mr. King was the 911 call that he made, again at the scene. Neither one of them were in custody at the time.
All right.
I don't have an issue with the 911 now.
Any other issues?
Did have a motion to prohibit opinion testimony, essentially where you have essentially someone who's put up and they've crossed that level of testimony from lay witness testimony to giving actual expert opinion without being qualified.
We're referencing a particular witness or type of?
Well, I believe what we have is with certain witnesses, sometimes they will be in a position where their testimony starts to bleed into opinion testimony. And again, I know based on your Honor's prior ruling, we'll address that once they come up to testify. I'll make sure to be extra diligent so we can address that in camera.
Okay. What else? What else for the day?
We also have the motion regarding redaction of evidence. However, based on the prosecution's position of what evidence is not coming in regarding interrogation videos as well as some other videos, we will confer with them regarding what videos they do plan, which I believe obviously is the surveillance camera. There won't be, I don't think this motion is proper at this time until I speak to them to know for sure exactly what they seek to admit. But if it's just the surveillance camera itself, there shouldn't be any major redactions. We did have some heavy redactions that would have been necessary for other videos, but it appears that won't be necessary to be addressed for the court.
All right. Any other issues before we come tomorrow morning and start with openings with the jury, preliminary instructions and opening statement? Anything else before that?
Not for the session.
No, Your Honor. No, Your Honor.
Okay, very good. 9:30 it'll be.